July 4th, 2026, the 250th anniversary of the Declaration of Independence. So, at any rate, as such, I'm going to talk to this tonight a little bit about some constitutional issues. As we know, the Supreme Court earlier in the week there did issue some opinions, one of which I don't think we liked very much, one of which I think we like quite a bit, and the other one, I don't know. I guess it's favorable to us, but it's kind of in the noise, I think. And of course, it's good that that they ruled that states can actually have biologically separate boys and girls sports teams. As I always said, if you're going to have boys on girls' teams, then why do we have girls' teams? Why don't we just have sports teams that anybody can be on? But if we don't accept that, we need to have something where girls can be competitive with each other and not have some boys in there to dominate the situation. That makes sense that they would be separate. And the court actually upheld that common sense thing, although I think the three females on the court ruled the other way, which is kind of interesting. all the battling that the women's rights movement has had for some time, to get Title IX and female sports, and now all of a sudden they seem to want to destroy it for a small clique of people that are mentally off. But at any rate, that's not the main topic. The main topic is the birthright citizenship issue, of course. And so I want to kind of address this. Of course, we lost on this one. I would say it ended up being what we might say. You could either say it was a 6-3 decision, or you might even say it was a 5.5 to 3.5 decision. And one of the interesting aspects of the whole thing, I guess, is the Kavanaugh opinion, which disappointing in one way and logical in another. And in fact, it actually leads to the question, why did Trump even issue that executive order the way he did? And we'll get into that later, of course, but we need to have to analyze the situation a little bit to see the constitutional premises. I think our three conservatives that voted to eliminate birthright citizenship of Thomas and we'll see here, Gorsuch, Anyway, and there's another concurrence there, and then on the other hand, we have our Roberts and the three women of Democrats, of course, and of course Barrett, and so anyhow, as I always thought that picking Barrett was a big mistake, because I kind of thought that if the Democrats have three women, that's enough to represent the gender. And what we really want is a result. And the women, a woman might occasionally want to side with the women. I don't know if that's the case in this situation, but or it may just be her viewpoint. But at any rate, I probably am kind of messing around with that statement. But anyhow, that's the way it turned out. Essentially, the arguments, if you read through them as much as I can follow them, are based on a whole bunch of historic precedents, arguments about previous cases, English common law, the way it was at various times in the history, what various states did or tried to do, and so forth. So it becomes a very complex issue. Of sorts, but it looks like that a person could logically argue either way if you were a sufficient legal scholar, and so it comes down to really what you want the answer to be, I think, right? I mean, I don't see that there anything in there that absolutely says it has to be one way or the other, and the whole issue is that the clause in the 14th Amendment, which says that basically that people that are born in the United States and subject to the jurisdiction thereof shall be citizens of the United States and the state in which they're in. So, and that was essentially passed largely to confer citizenship to the freed slaves after the Civil War, because of certain tendencies, I think, in certain southern states to pass laws that would basically deny them the right to vote. And of course, that was a battle that raged on for a long time to the Voting Rights Act and I think a constitutional amendment against the poll tax in the mid 60s. So at any rate, so that's kind of the way that goes. And I'll kind of go through this to explain what happened. But if you like these videos, please give me a like, subscribe, click the bell for notifications, or you can also follow me on Rumble because I post there as well. Yes. So, okay. So the interesting thing about this is, I mean, it all comes down to what does subject to the jurisdiction thereof mean? And that becomes a debatable thing. You could argue anybody in the United States is subject to U.S. law. I mean, right? If a illegal immigrant commits a crime, they can be tried and convicted under U.S. law and sent to prison, right? So that's true. On the other hand, the other meaning I think that comes into is where is their actual loyalty? Where is their real citizenship? Because if they were a citizen of another country, whether it be the UK or Mexico or whatever, they have rights, and under that, they potentially have the right to have a passport to that country, and they could, go to the consul or embassies there for assistance, and presumably would get support. You see, so in real sense, they are foreign nationals in a lot of ways, perfectly, and of course the kids, that gets into various laws and so forth. So essentially, I think one of the interesting things about the Kavanaugh decision, which was interesting, was kind of that's why I call it a half. He basically rules against the idea that birthright citizenship is a constitutional right under the 14th Amendment, but rules that Trump's executive order violates the statutory law that was passed in 1940 and 1952, in which the actual text of that was actually written into the statutory law. Gets kind of nuanced here. But in other words, the statutory law essentially, it comes down to the fact that when it all comes down to a Wan Kim Ark, a Chinese person, well, a son of Chinese immigrants, and he had traveled overseas, and then they wanted to deny him entry back in the country, and this went to Supreme Court in 1898, and basically ruled that he was a citizen. Now, the decision also had in it 4 exceptions, however, to being simply, because you could already argue the situation, if they really meant to say everybody born in the United States territory, was a U.S. citizen, why didn't they just say that? Why the flowery language about subject to the jurisdiction thereof, right? Why not just say anybody born in the United States is a U.S. citizen? That would be cut and dried. But that's not what they did. In fact, there's a similar problem on the Second Amendment too, about to have a more regulated militia, blah, blah, blah. Okay, but we're not going to address Second Amendment issues here on this one. But the point I'm making is that the 4 exceptions, if I remember them correctly, were foreign sovereigns or their ministers. It was people that were born on foreign ships. Okay, I guess like if they're born on a ship, but it's on a foreign ship, not actually on the ground. I guess that could even be in a port. Good question. People born to people in which the United States was under invasion. In the hypothetical scenario, which they even covered that the United States was being invaded and somebody was born, the foreigners on U.S. territory that was under occupation by a foreign power, they wouldn't be citizens. And the final one was, of course, members of the Native American tribes. Well, I think they said Indian at that time, I believe, but we know who we're talking about here. And because at that time they were considered nations, sort of separate, and were treated that way, and we signed treaties with them and then broke them. But that's another question. But we did have treaties with them. So there's no other group in the country we had treaties with. We didn't have treaties with freed slaves, for instance. We didn't have treaties with illegal immigrants, as we call them today. Now, one of the key things that has to be understood here about this decision, this objection he had, which some people hold it out as some kind of hope for the future, maybe, and that would be essentially these exceptions here were things that were not necessarily, as I understand, absolute. They were just ones that they made at the time as part of a decision. So the Supreme Court at a later date, hopefully earlier this week, but they didn't, could have argued that, well, first of all, at that time, the current concept of immigration and illegal immigrant and all that really wasn't an operative thing at that time. Okay, I mean they didn't necessarily weren't here illegally because they weren't violating the law, but they also his parents weren't citizens either. So the result is that as that Juan Kim Art guy. So. However, since that time, laws have been passed which are constitutional, which do define immigration statuses and who's here legally and who isn't, and all that sort of thing. And so things have moved on since then. And so since they were arguing essentially, I think this is what he's kind of saying, that since they were making pragmatic exceptions in 1998 when they made, 1898, I apologize, 1898 when they made that ruling, it would make sense as later dates, if some conditions were to change, then you could make include other groups, such as illegal immigrants or people here that are here temporarily, like passing through. I mean, so that would deal with anything like the whole idea of birth tourism or the illegal aliens. Okay, but since that time, the Congress had passed that same language into statutory law. 1940 law and 1952 law. So the issue is that the reason why Kavanaugh ruled against Trump was because his ruling ignored, or if you will, rejected existing statutory law, which had not been repealed. And that's why he ruled with a majority. But he dissented with them that it wasn't a constitutional issue and that Congress could, if they wanted to, simply change the law and make these also exceptions to birthright citizenship, essentially. So, however, the likelihood under the current situation is small. It's an interesting question, even if the filibuster were abolished by the Republicans, which I don't think they're going to, as I've said before, but if they did, at least not this year, would the current Senate actually still pass such a law? That's a good question. I mean, considering some of the people we have that are kind of not exactly in good standing with Trump at the moment, and we have, as I say, the same people that won't eliminate the filibuster may not vote for that either. I don't know. I think Cornyn would probably still vote that way, I think. But I don't know about somebody like Murkowski, and Collins probably wouldn't, because if nothing else, it would be used against her in her election campaign in Maine, and So at any rate, some things are pragmatic and some things are real. And so anyhow, so that is a possibility that if Republicans in the future might potentially pass some laws affecting this, and then it would have to go back to court again. However, with the same set of 5 people, I think that ruled for absolute birthright citizenship, it would probably still fail. But maybe with different memberships on the court. At any rate, that's the basic argument, which is why I call it a 5.5 to 3.5. But so anyhow, that's kind of the rationale. The other people just went full scale, basically, for this idea of English common law, and the 5 that were completely the majority, and the other 3, well, they're Democrats, and so they're not voting on any kind of real, that's what they cited, but in reality, I think they just wanted it to be that way politically, because I don't think they have any real, they have very little judicial integrity. I won't say none, but I mean, considering their issue on the, I think the main thing that they didn't like about the majority opinion in part was the fact that they didn't want transgender to be a protected class. And I think, as I understand, I think that was why that would really set them off. But anyway, so that kind of just give you a little bit of insight into what the ruling was. I think it's kind of fascinating in a way, but it's also, in my sense, kind of baloney, because let's face it, I mean, marriage between man and a woman was totally established forever, and the Supreme Court, ruled for gay marriage, right? What was that, about 12 years ago, something like that. The exact date I don't recall, but it was in the mid-teens. With a different composition of justices, And but it does show you that they can make completely radical decisions arbitrarily, and on the other times they have to follow the minutiae of a previous decision because they just gotta, stand with, we made a bad decision once, so we gotta stick with it. Otherwise, no stare decisis. So whatever. At any rate, that's kind of my little pitch on that. If you find it interesting, I hope. Um, Moving on to, well, in closing there, I didn't have a lot of viewership on my last video, which was a little bit too long. I apologize for that, but I do think had some important stuff in there. And in fact, I covered different angles on the subject as well. So the issue about the risk of a NATO-Russia war occurring as we continue to support Ukraine attacking targets inside of at Russia, which I think could go in a very disastrously bad direction at some point in the future. Not to say it's going to happen this week or next month, but I'm saying the trend could be very bad, I think. And so I'll wrap this up for now, and as always, I'll be posting this on YouTube and Rumble, and the description of my social media accounts addresses will be in the description below. So all for this time.